Hi, thanks for using my court coach. I'm Sarah and I'll be your instructor as we talk about the Spousal or Partner Support Declaration Attachment. This form specifically addresses and discusses the factors that are set forth in Family Code Section 4320. These are factors that the court has to consider whenever they make a final determination on spousal support or consider a post-judgment modification of spousal support. It is a quite detailed form, and the more information you can provide on it, the easier it is for the court to be able to make a decision on your request for consideration of spousal support. This form can also be used to request attorney fees. If you are requesting attorney fees from either your former spouse or current spouse. This is not a standalone form. This is a form that is often attached to other pleadings. And so you can see under the header, Spousal or Partner Support Declaration Attachment, there are a couple options to identify what documents this form is being attached to. It can be attached as part of a default package, in which case you would mark the box that says Declaration for Default or Uncontested Judgment, the form FL-157. You would use a default if you have properly served the other party with a petition and summons requesting a dissolution of marriage or legal separation, and that party has not responded in a timely manner. You can then ask the court to default them out of the process, which means they do not actively participate in the case. You would attach this form to your default judgment package because it allows the court to be able to make an informed decision on your request for spousal support. You can also attach it to the supporting declaration for attorney fees and costs attachment. In more recent years, the court has been requesting that this form be provided to give the courts an overall purview of each party's financial standing in making an order for attorney fees stemming from two parties that were married together. And then there's other. Other is typically going to be, and most commonly going to be, when you're requesting a final determination of spousal support, usually at the trial stage, or a post-judgment modification of spousal support. Below these categories, you can see that there's an option to either request that the court make orders on spousal support or attorney fees. We'll deal with the spousal support orders first, and you would just check all that apply. If you're asking the court to make that final determination on spousal or domestic partner support, then you would mark box 1A and identify if that support is going to be for the petitioner or respondent. If this is a post-judgment modification of spousal support, then you would mark box 1B and again identify if the support is, the recipient of the support is the petitioner or respondent. If you've been served with a post-judgment modification of spousal support and you want the court to deny that request, you would mark box 1C. And if you are asking the court to terminate jurisdiction to award spousal support to either petitioner or respondent, you would mark box 1D. What that means to terminate jurisdiction is to terminate the court's ability to ever award spousal support again as a result of this marriage to a party of the case. If you instead are requesting attorney fees and cost, ignore field 1, focus on field 2, and you can see 2A has the ability to request that your attorney fees and costs be paid by either your spouse or if there's a joined party to the case that you believe has an ability to pay your attorney fees, you could mark the box that says joined party and specify their name. Or if you have been served with a request for attorney fees and costs and you want the court to deny that, you would mark box 2B. As I previously stated, this form goes over all the factors that the court needs to consider in making a final determination of spousal support. And this form breaks those down into different fields. We start with what are the supporting parties' training, job skills, and work history. Whatever that is, if they've had any education, higher education, you'd want to list it here. Any sort of specific training in a field, you'd list it here. If they worked several years or maybe only a couple years in a particular field of employment, whatever it is, you would list it here. And again, the more details you can provide, the more helpful this form is and the information contained therein for the court. Line or field A3A2, you would list how the job market is for the types of jobs that the supported party is qualified for, whether it's a strong job market, a weak job market, whatever it is, you'd want to list it here. And any supporting information you have for that is great. For instance, if you are living in a tourist town and the job skills of the supported party have always been at tourist attractions, then you would state in here the current job market is very strong for those job skills, etc. Field 3A, 3-4, they're kind of one and the same. It's asking if there's any additional training or education that the supported party would need in order to either develop or acquire a job, particularly focusing on what job skills they already have. You would identify how much time it would take to obtain further training, education, and what expense would be involved with that. And in box number 4, you would identify what specific skills they need training or education on. Page 2 of the form, on field 3B, you would provide facts that indicate the supported party's earning ability is or is not lower than it might be if he or she had not had periods of unemployment because of the time needed to attend to domestic duties. Most typically, this pertains to stay-at-home parents. If a parent has chosen to stay at home to take care of young children and had to take time out of the workforce, then that's something that you'd want to further expand on in this field. 3C, facts that the supported party contributed to the education, training, career, position, or license of the supporting party. A good example of this, let's just say wife was a nurse and she worked while husband attended medical school so that he could become a doctor. Something like that, some active support, not just passive support as in I encouraged him and told him good job, but active support that the supported party did at one point or another to advance the career of the supporting party, then you would list that here. Section D, the supporting party. You'd want to identify whether the supporting party does or does not have the ability to pay spousal or domestic partner support. This is not whether they want to pay support or not. This is whether, looking at it objectively, do they have the ability to pay support? And part and parcel of that, for the court to be able to make that determination, they want you to list the supporting party's current gross income from their employment, which you would list under D2. Any income that they might be receiving from investments, retirement, or other sources gets listed in D3. And anything else, any other form of income that they're receiving, you would expand upon and list in section D4. Section D5 asks for the supporting party's standard of living. Typically, you want to focus on, was it lower class, middle class, upper class? And this is what I call our show not tell segment. Rather than just say we lived a luxurious lifestyle, you want to show the court how it was a luxurious lifestyle. How many vacations did you take? Were you staying at 5-star resorts? What kind of cars did you drive? Were they always purchased brand new? How large was your house? How many square feet? How many bedrooms? What restaurants did you dine at? How many times a week would you dine out at? And what sorts of stores would you shop at? So you really want to expand on that here. And by the way, if any of these fields are not large enough, feel free to attach a separate sheet of paper and continue the explanation. Just make sure to identify what category you're responding to at the top of that paper. Section 3E, does the supported party, the party that is requesting the support, need the financial support in order to maintain the standard of living? They either do or they do not. You want to mark the appropriate box. And again, the court has to make a thorough analysis of this. And so they ask you under 3F to list what the supported party's assets and obligations are, and the values and balances of each. Below that, to compare, they ask you to list the supporting party's assets and obligations as well as their values and balances. Page 4, Section 3G, please list the length of the marriage. You want to include not only the number of years that the parties were married, but the number of months, and that goes from date of marriage to date of separation. And then Section 3I, list the petitioner's age, list the respondent's age. Below that, describe the petitioner's current health condition and the respondent's current health condition. Either it's good or it's poor, and if there's any ailments that either party is suffering from, you would want to list that here, and if it impacts their ability to earn income, particularly, you would want to include that as well. Finally, we have our catch-all section, additional factors that the court will consider. Those all go down into this box, starting with any documented evidence of domestic violence between the parties. The finding that there has been domestic violence can be a barrier to a party receiving support. So if that is the case, you definitely want to identify that here. J2 asks for the immediate and specific tax consequences for each party. Prior to 2019, it used to be that spousal support was deductible by the party who was paying it and had to be reported as income by the party who was receiving it. The tax code changed as of 2019, but if this is a post-judgment modification of a support order that was ordered prior to 2019, then those tax consequences can still apply, and you can indicate if you want to grandfather in those tax findings for each party. J3 asks you to weigh the balances of the hardship on each party. Obviously, we are dividing one household's income into two, and it's going to be a hardship on each party, but if it swings drastically one way or the other for one of the parties, then you would want to identify that and describe how it does so. 4, this is similar to 1, the criminal conviction of an abusive spouse in reducing or eliminating support. As I stated previously, that the finding that there has been domestic violence perpetuated on a party by the other party can be a barrier to collecting support as to the party that perpetuated the domestic violence. 5, this is actually a really important one. The goal that the supported party will be self-supporting within a reasonable period of time. What is a reasonable period of time depends on the length of the marriage. If this is a short-term marriage, in other words, if it is less than 10 years long, typically the court is going to terminate support at half the duration of the marriage. So if it's a 10-year marriage, then a person can reasonably expect to receive support for 5 years. This is not a black and white rule, but this is just sort of a guideline. If it is a long-term marriage, such as a marriage of 10 years or more, then the court will not set a termination date, most likely, but at least you want to put the other party on notice. It's called a Gavron warning that they need to become self-supporting within a reasonable period of time. This is really important language to ask the court to order. And then 6 is our catch-all. Any other factors the court determines are just and equitable. If there's anything else that you think is significant for the court to know in making its order or determination on spousal support or attorney fees, you would list it here. I hope you found this form helpful and my explanation of it helpful. Good luck.